So once again, welcome one and all to this afternoon's part 2 of the VLA Bootcamp series. And today's topic is on intellectual property basics and real-life applications. My name is Katie Steiner. I am an associate at the law firm of Hahn, Lozier & Parks here in Cleveland, where I'm an associate in the firm's art law and nonprofits group. And I have I'm currently serving as the chair of the Volunteer Lawyers for the Arts through the Cleveland Metropolitan Bar Association. And I have served as a proud volunteer with this group for as long as I have been a lawyer, which is about 3 years now, shockingly, amazingly how time flies. But we are delighted to bring to you a group of 3 of our very dedicated and talented volunteers, long-serving members of the VLA, to walk the group through some the basics of intellectual property, patent topics, copyright topics, and trademark topics. These are topics that regularly affect the artists who we as a group of volunteer lawyers serve. And once we, the idea, the structure of our boot camp today is to provide an overview of some of these intellectual property legal concepts that regularly come up with clients who apply to the VLE for pro bono legal services. Walk through those concepts, but then take some time to apply them to some real life scenarios to give both lawyers who are joining this call, but also any artists who are joining this call as well, a sense of, what are some things to look out for? How do volunteers typically, approach these issues when they occur with clients, pro bono clients who we serve, just to give everyone a sense of if I am interested in volunteering, which we certainly hope you are. We would be delighted to add new volunteers to our ranks, but we certainly hope to give those new volunteers a taste, a flavor for the types of work that we do as a committee, but also to encourage artists who might be tuning in to maybe have a sense of, what types of issues they can apply to the VLA for, ways that we as a group can assist them as well, and just kind of raising awareness of some common issues that the artists who we serve face. So, and one other thing that I will just mention at the top is that if you are an attorney and if you are tuning in today for CLE credit, we will put the details for applying for that CLE credit in the chat feature. So just take a look at that for further instructions and details. So with that said, I am going to turn it over to each of our 3 panelists today, each of them in turn, who are presenting the overview, the intellectual property overview, which I mentioned just a moment ago. And I will let each of our panelists introduce themselves. And so let's go ahead and start off with Ed. Ed, take it away, please.
Excellent, thank you. As I will share shortly, this overview of mine is a very broad-based overview. Tom and George will augment several different features of my overview. I am a patent attorney with Walter Haverfield here in Cleveland, Ohio. I've been a patent attorney for a number of years, and before that I was a patent agent, sort of like a secret agent. I didn't have to kill anybody, but it was a stepping stone from my previous careers that were in technical areas, and then management. And then I found out while I was in management that I needed to have a technical touchstone. So I went back and studied for the patent bar, passed it, went to law school, and all that nice stuff. As I mentioned, I will be providing a very brief and broad overview, and touched on a number of points. There will be no test at the end, so if you get lost in the middle of it, don't worry, you won't be penalized. With that, I will do the share screen aspect. And away we go. I'm calling this the CMBA VLA Bootcamp, PDQ, IANYA. Everyone loves acronyms, right? Well, geeks like acronyms anyway. It's pretty darn quick. I am not your attorney. The reason why I mention that is that it is always important to not assume that you, when talking with the attorney, that you're being represented by an attorney. This works both ways, protect you and to protect the attorney. And we'll touch more on that in a little bit. Some simple suggestions and not so simple caveats. Like I mentioned, this will be very quick. There are some simple laws. Basically, what do you want? When you're looking at IP, it's very important to understand what you want. And there are some simple caveats that apply to that. I've broken it down in different areas that IP cover. And then there's also some simple, not so simple caveats and trade-offs that follow along with it. And at the end, I also share some suggestions of source material for you to go and find out more information. Intellectual property comes in a lot of different flavors, as you might imagine. The ribbon with the nice little red thing is a patent, and there's also patent pending status. The C in the circle typically is copyright. R in the circle and TM are trademarks. I threw in a little bit of a warning sign there because there's another form of intellectual property out there called trade secrets. That's kind of an odd animal all on its own. But we'll move on. Simple laws are for different things. Patents protect utility, copyrights protect expression, and trademarks protect both business and public from business confusion. Trade secrets protect developed know-how. I have that kind of in shadow form there because, again, trade secrets tend to be a shadow. It's also a shadow because everything else involves a level of sharing of your secrets. When you obtain a patent, you have to share with the government the background to the patent and to be able to make it use what is a legal term of person of ordinary skill in the art can make and use. Of course, when you're sharing your copyright material, you are generally sharing that openly. And trademarks, of course, are broadly shared and pronounced in advertising. And their purpose is easily seen when shared. The item about know what you want, personally and professionally, is this is one of my chief counseling points with new clients, is understand your own plans. There's a whole host of reasons why one might want to obtain intellectual property protection. There's no single wrong reason to do it, but it's important to know your reasons because most often these reasons go to a business plan. And if you do not plan, then you're planning to fail. There's always risk and reward involved in this. There's cost involved in this. And the best way to understand the cost is to put it into your business plans. The simple one and a major one is I am not your attorney and this is not legal advice. The main reason why I say this is because I am not your attorney and this is not legal advice. This is a shared forum for education purposes. You should not take anything said either by myself or Tom or George, any of this, and say, well, a lawyer told me this and therefore blah, blah, blah. No. This protects both you and attorneys. If you do such a thing and you run into trouble and then you turn around and try to sue the attorney, you're not going to go very far. Also, it protects you so that you understand when you actually have an attorney-client relationship. Money and why bother? The other simple caveat here, like I mentioned, the business plan, money is behind most everything here. Money is the root of the property portion of intellectual property. And again, most times you want protection to protect your business goals and assets, but not always. Sometimes you just want to protect your creativity. Copyright, patent and trademark copyright, as a simple caveat, is the easiest to obtain, but carries the thinnest protection. By thin, I mean there's a lot of distinctions of fair use, and Tom will probably go into more detail on this. But it's also the easiest to obtain. You put something in a fixed media, writing, video, things of that nature, and you have earned copyright protection. You can register your copyright protection if you want to enforce it in a court of law, and that's a pretty straightforward and usually the least cost impact step of protection of the different forms of IP. Patents are the most difficult to obtain, but also may serve as the strongest. But even this has its own caveats. By strong, I think I kind of remind people like trespass. Intent is not required for you to run afoul of someone else's patent protections, and knowledge is not required. And you might be able to serve with a cease and desist on something that you thought that you've always been able to do, but someone has a patent on it and they find out you're doing it, and all of a sudden you are no longer able to do what you thought that you always were able to do. Other simple caveats on the trademark side: trademarks are more intricate from a legal standpoint because trademarks have something called non-federal preemption. They exist state by state as well as in federal law. I'll touch upon that a little bit more briefly deeper in here. Again, no quiz, so don't have to worry about not remembering it. Trade secrets fall generally under trademark law, but does have some intersection with patent law. And as well, there are some recent federal developments on trade secrets. Now, this is the part that everyone loves, right? The legal basis of protection, government in general, not so simple caveats. This is a civics lesson that you will not be tested on, so I will go quickly. We, the people that probably should be easily recognized, underneath that, there's a pyramid, layers and policies until you get to the bottom of actual people. At the top, life, liberty, and the pursuit of happiness from the Declaration of Independence actually stems from a slightly modified phrase, life, liberty, and property. And the property aspect is one of the aspects of intellectual property that is tied into the protections that you see that have been built into our system of government. Layers and policies include both federal and state governments. We actually live under two sovereigns, and states' rights actually impact some of these areas in different areas, like I mentioned, in an area of non-preemption. In areas that are preempted, that are mainly driven by federal law, such as patents, there are aspects such as communal property laws that have state-to-state impacts. So there is a tangled web of multiple sovereigns that involve these intellectual property rights. Like I mentioned, it's not so simple. The legal basis of protection for patents and copyrights, Article 1, Section 8, Clause 8. There's some examination and general requirements, and then there are some keep-outs that you may not be able to do or protect. General requirements include eligibility, the type of thing that you want to gain protection for patents. Novelty, non-obviousness, enablement, and possession are other key critical elements of patent law. Original work for copyrights in a fixed medium, creative expression. Keep outs, patents, there are many related to each of those different things that I mentioned. And in copyright, some of the keep outs are you have to actually have it fixed in a tangible medium. It has to be original, creative to a certain level, and it cannot be functional. Function is usually reserved for patents. The legal protection on the trademark side is a little bit different. It comes from the Commerce Clause, Clause 3, and this difference does show in the fact that it's to protect both businesses and the public from business confusion. Businesses like it because it helps them in advertising, and they have their mark that only they can use. Consumers actually are benefited from being ripped off with shoddy goods of something that they think that they're buying at a certain level of quality, and all those things tie together in rather important ways. The trade-offs, as I mentioned, powerful but typically expensive, copyright easy but then coverage, trademarks tied to a legitimate business, Trade secrets have a variety of complex but potentially unending power. As long as you can keep a trade secret secret, you have some power to it. Each of these are up to you to police and enforce. That's another item that I wanted to mention. Just because you have a patent doesn't mean that the government's going to come by and protect you and enforce your patent for you. That's part of the business aspect of putting in your business plan, is not only obtaining rights, but making sure that you have enough wherewithal to enforce the rights that you may obtain. So at the source, patents, uspto.gov, copyright.gov, uspto.gov, trademark for trademarks. Trade secrets in Ohio can be found, generally being spoken of at codes.ohio.gov. It's interesting to note that even though patents and copyrights come from the same constitutional clause, the government has seen fit to place those in two different government areas. Trademarks were put with patents for whatever reason. That's the broad overview. I will now turn it over to Tom.
Actually, Ed, first of all, thank you so much for offering that really wonderful overview, which really situates the topics that remain to be discussed. So thank you again so much for that input. Before we transition to our next speaker, I just want to dive in and say that if you are tuning into today's presentation, once again, welcome. But if you have any questions for any of our panelists at any point throughout the remainder of this hour, please feel free to put them into the chat feature, and we'll be sure to monitor those questions as they come in and interject them as necessary. So with that said, I'm actually going to move now to our next speaker, which is George. And so George, please take it away.
Okay, lucky me. Let's see if I can do this the first time I've had to do this, and share. Okay, we sharing this? Wonderful. Everybody can hear me. My name is George Geddes. I do a variety of things. I'm a solo practitioner. One of my major clients is Oxeye Media, which is a comic book and board game company located in Michigan. And I'm kind of serve as general counsel to them, as well as a few other clients. I have a pretty large background in intellectual property law, and today I've been asked to talk about trademarks. So really quick overview of what we're doing here. I can, that's weird. So we're basically going to look at what is a trademark, what is protected, and what's some of the basics about the registration process, both what goes on, why you should register a trademark, or even if you want to register a trademark. In some ways, it's not important. And then we're going to talk a little bit about what about. So some common questions people will come up to you, come up to an attorney and ask about a trademark. And so you're not left entirely flat-footed, because I hate when that happens when people ask me about insurance law or real estate. I got to go, I don't know, talk to a real estate attorney. So at least you won't sound that silly around them. So first off, so a trademark is technically a distinctive signifier affixed to goods for sale to identify the source and distinguish them from other goods. So this is an important part of the trademark itself. It has to be linked to a good or service. It just can't exist by itself, unlike, say, a piece of technology in which you can get a patent for, or an artwork which a copyright applies to. It has to be attached to a work, meaning the trademark has to be, in order to be valid, has to be in use. And we'll talk a little bit about that with the registration process. And like a copyright under the 76 Act, it exists as soon as it is made, or in this case, as soon as it is affixed or attached to a good. Now, this doesn't necessarily mean a label. It could mean marketing descriptions, anything like that, but it has to be linked up to some sort of good, and it exists. The first thing that kicks in is common law. This is usually state law. Ohio has some special provisions, but usually you can get a trademark under state law through use as well as registration. But this is usually considered a very weak form of trademark. But essentially, if somebody comes up to you and asks, do I have a trademark? Question, are you actually using it for your business? Yes, I am. You have a trademark. The problem is it's not going to be so effective if you want to go after somebody in, say, Texas. Okay. That's usually when federal registration comes in, or under the Langham Act, which is done in the late 40s, is our current trademark law regime. And that covers federal registration. That gives you more of a national copyright, a national trademark. But as we see, as we'll go through this as well, that it doesn't automatically give you the right to use it everywhere in the U.S., because you still have to deal with existing common law copyrights or common law trademarks or state trademarks, which might be in use before you used your trademark. And courts have different ways to deal with this, and that's kind of outside the scope of this, but something to keep in mind. A quick practice tip, again, a question you might often get, and you've got to go, I don't know, is often you see with trademarks attached a TM or an R with a circle. And people ask all the time, artists ask, when can I use this? Or can I use this? The basic rule is TM covers common law or regular trademark use. So if they're trying to establish a trademark by itself, it would be effective to put a TM next to it. The R with a circle is reserved only for things that are registered with the USPTO. So if you've gone through the trademark process and you've registered it, it's been approved, and publication, and it's been issued, you can then use the R with a circle, but only until then. And it could be considered fraudulent in some ways if you do use it without that registration. So if somebody doesn't have a registration, they can put TM, signifies it's a trademark, and actually starts to build that brand. Because as I said, it could, when it's affixed to the good, it doesn't exactly mean a label on the good. It means when it's attached to it in some way. So if you're using it in marketing materials or something of that nature, or a website, if you put, whammo, little TM mark, or parentheses TM, close parentheses, you're starting to use it as a trademark and putting people on notice that you're using it as a trademark. So that's helpful to show first use of that trademark. Okay. Let's see if I can do this a little. Okay. So, okay. Sorry about this. There we go. So what can be trademarked? This is really an open-ended question in some ways. It's basically a signifier, as I said, a signifier affixed to goods for the sale or to identify the source of the good. Okay. Now we have a very famous mark there to the right, and there's some special things about that I'm going to talk about. Generally speaking, the basic trademark is the word mark, as they call it, or the text. So in the trademark to the right, it is the words Coca-Cola. Okay. It's not the script. It's not the shape of the bottle. It's not the red dot or anything like that. It is the words Coca-Cola would be the word mark. Okay. Graphics. Now, in this case, we have a graphic. Now, graphics are a type of trademark you can register, logos, things of that nature. Shape. Shape can be registered as a trademark. In this case, we have the famous shape of the Coca-Cola bottle. We also have color. Okay, Coca-Cola hasn't registered red. Probably the most famous color registered is Tiffany blue, that people might recognize. Also, as well, the pink associated with my Owens Corning fiberglass is also registered as a trademark. Now, this is an important thing to bring up, which I'm going to bring up a little bit later about registration, which is the way trademarks are categorized, because they can be used you can use a trademark for almost anything. They have certain classes. There's 42 international classes, which roughly categorizes all goods and services that one could provide, and their general headlines. Chemicals, I think, starts it off. Machinery includes automobiles, things like that. Generally, entertainment services, educational services. These are all different classes. Now, this is important to bring up about things like color, right? Owens Corning might own a specific color pink, right? But that's only applied to the class of goods for insulation and maybe building materials. That doesn't mean you can't have a pink car, okay, or sell things with pink. Okay, you can easily do that, but just covers only for that specific class of goods. Interestingly, you can also trademark sounds. I'm going to see if I can do this sound. And anybody hear that? I guess I give up on that one. Again, first time using this with Zoom. I have no idea how things go. That's actually Homer Simpson's very famous "do," which is actually a trademark of 20th Century Fox. Now, again, this has to be used in conjunction with goods. So in this case, it was probably registered for anything from entertainment services, right, to dolls, right, dolls with a little pull string going with the dough. Other sounds that are registered you might be familiar with are the NBC chimes, right? 3 chimes we automatically familiar with, okay? And there could be other things that can be trademarked as well or tried to trademark. The law is very general with what we're talking about as far as signifying a good or service, right? There's been attempts to, so it could be a 3D representation of something. Even mannerisms and actions have been tried to be trademarked before. Those have been roughly unsuccessful in registering with the USPTO, but they are allowed certain common law protections, because as we said, you have this common law underlying the major registration thing as well, okay? A little practice tip, again, to be aware of. Word marks are usually the inherently strongest form of a trademark. And what I mean by that is if you're Coca-Cola and you just register the mark to the right, that covers that specific trademark. It doesn't necessarily cover the words Coca-Cola. So somebody could use the words Coca-Cola and put it with a blue square and a triangular bottle or something like that. And that would not be considered a trademark violation of that specific trademark. But if you register the words Coca-Cola, well, there you go. You would cover both anybody using that word by itself, but it would also include the use of that word in that graphic. Okay, so if somebody says they want to register their trademark and you look at it and you go, well, that's a great picture, you're a lovely artist, but really the trademark you want to register is that type and that what you write there. Okay, so is my mark enough? So basically, these are the questions you're going to see if you actually have a trademark and something you can at least take an action on and make a decision about. Number one, is anybody else using it? This is an obvious thing, priority, right? You can search the USPTO database online. You can search state databases. Keep them, and you can actually hire firms that'll do their own trademark searches for you. A lot of these things are still, it's not 100% guarantee, because really somebody could be using something on a corner and be famous on that little corner in that little neighborhood, and they technically might have a trademark that might trump yours under the common law. But again, those are kind of rare cases, and the courts have different ways to deal with that situation if it ever becomes a problem. But the first test, obviously, is anybody else using it? If somebody else is using it, probably not a good idea to use it yourself, okay? That comes to the next one. Are you using it? Again, it's effective when it's affixed to the goods. If you are planning something, if you are planning to launch a product, a service 2 years from now, and you have this great idea for the name of the business, well, if you're not conducting your business, you don't have a trademark yet. You can't register it. You can't protect anybody else from using it because you're not using it technically under the law. It's not affixed to a good and service. Now, from here, the courts have generally looked at types of marks and usually about how distinct they are, right? If I come up with something that is very unique versus something that people use every day, what are you going to do? Okay. And they're generally put into these 5 things. Fanciful, Clorox is a good example of this, an entirely made up word. Kodak is also considered a famous example of this. Arbitrary. I have Penguin I have Penguin Books here, or Penguin Publishing, I think it is technically. But that's a word that exists, penguin, right? But it has nothing to do with a book, right? Not describing a book or anything like that. It's just the name of a publishing house. Okay. Suggestive, Coca-Cola. Now, this might be a little bit weird because it's a famous thing, but usually it's something that is somewhat indicating what it is, but not really. All right. So Coca-Cola, it's new. It's, I don't know, but back when it was done over 100 years ago, it somewhat indicates what the good is, but it doesn't really say what it is. Okay. Now, those first three are usually inherently distinctive. Okay. Meaning you're automatically able to get trademark protection for those, or at least it's determined to be at least distinctive enough to get trademark protection. But then you get into this weird area where you have descriptive, right? Whole Foods is an example of this, right? It's a trademark attached to a grocery store. Well, that could be describing the food in the store. In fact, many people might consider the food in the store to be a whole food. So that's something that would be more describing it. And those are kind of in this weird gray area, whereby if you get famous enough, and we'll see some examples of these as we go on, about special situations where these are, you can register this as a trademark, right? If you tell people I went to Whole Foods, everybody is going to know, oh, you went to that grocery store. Not, oh, you went to a store that sells Whole Foods, right? So, so that if usually those are registered on this what's called the secondary register, and there's a separate process. Again, a little bit more advanced for what we're talking about here, but that's one of the things. Finally, there's generic trademarks. Okay, now generic is usually used for a word that is really descriptive. Everybody uses it every day, or is everybody uses it and it's really hard to not use that. You know, for example, if you want to refer to a car as fast, right? This is a fast car. Well, that's used by everybody for everybody. You know, you can't really register it as generic. Some marks become so well known and they're not registered or protected, they fall into being generic, which is a process called genericide. Frisbee is a very good example. Okay, Frisbee started out as a pie company, turned into a toy, but nobody's registered the trademark Frisbee. And so now everybody uses it for the toy. And yeah, I know people use flying discs and things like that, but Frisbee might be a good example. But companies really go off and try to protect this. That's why you get stories about how Xerox or FedEx or Google even sending letters off to different companies saying, stop using our trademark, or you referred to our trademark this way, please stop this, because people are starting to use that word and it's becoming generic to say, I have this question. Well, Google it. Well, that's using the trademark and protecting. I'll FedEx you it tonight when I could be using UPS or the Postal Service or whatever. Okay. So other distinctiveness. Now, these are some well-known examples. Okay. Surnames, your last name. Generally, it's not trademarkable. Okay. Meaning it can't be registered. There might be some common law protection to it, but generally you can't register your last name. That said, if it gets secondary meaning, right, you might be able to. Surnames are considered descriptive in nature because they're kind of describing yourself and your good. And they're also used by so many other people. If I want to sell Smith brand pencils, well, there's probably lots of Smiths out there selling pencils. Okay, letters and initials. This, generally speaking, no. I mean, we have famous three-letter names, and I mentioned my NBC just a second ago, or IBM. Those are registered, but they're registered with the secondary meaning. They're become so famous. If you randomly want to just, if I wanted to trademark my initials, GCG, for legal services, the USPTO will say, there's the door. So slogans. Now, this is a gray area as well, because sometimes 3-4 words usually can be registered, but if you have some long sentence slogan, probably not. It has to be something small and compact. So if somebody wants to register a paragraph they use in an advertisement as a trademark, you're not going to get that done. Titles of works. This is interesting, especially when it comes to arts, okay? The title of a book you've written, a title of a song, is generally not a trademark, even under the common law, because it's considered descriptive of the work, okay? If you think about this, how do you describe a book, right? Well, you describe it by the title. How do you describe a song? You don't hum it out usually. You say what the title of the song is, maybe the artist. It's descriptive. So generally, titles of works are generally no. This affects me in my work in a regular time about books and games, because the titles themselves usually cannot be trademarked unless you get into some special situations, which you might be able to dream up, but we're not. Generally speaking, titles are problem. National symbols. This is might be obvious, but some people misses out. You want to use the American flag on something and keep that as a trademark. Ain't going to happen. That's actually statutory by law. A lot of these national symbols are forbidden to be registered. Geography. Place names, right? Geography is generally a maybe. And I know that's really unsatisfying, but it's basically because it's supposed to talk about the origin of the good. Well, if you're talking about a geographic place, it might imply where the good is from. So it will lead to confusion, okay? So generally geographic names like Cleveland T-shirt company, probably not going to be able to be registered because anybody could be making T-shirts in Cleveland and it would lead to confusion over who's making the T-shirts, okay? Now, I mentioned suggestive and descriptive. There's some real gray area here that a lot of attorneys play with, right? Whether or not something is descriptive or suggestive. And keep in mind that this might be a problem if anybody comes to you looking to trademark something. You might have questions about whether it's suggestive or descriptive, and sometimes it's worth taking the risk to register and seeing what happens. Maybe you'll end up in tab, the appeal board. Maybe not, but it's something to keep in mind. Okay. Registration. And the other common question you're going to get is, why do you want to register? How am I doing on time?
George, actually, yeah, Katie here. I think we're going to, if you don't mind, let's call it there. If you want to make any sort of concluding remarks, that's totally great. But I just want to make sure that Tom has an extra moment. I think actually, for what it's worth, I think hopefully in the panel discussion, we'll have an opportunity to talk about registration and some of the priority issues that you mentioned earlier, if that's okay.
Yeah, let me wrap up my last few slides really quickly. Okay,
sure.
So registration, it's something to consider strongly. It costs about $350, $400, depending upon certain things for one class of goods. Something to consider. The best thing about this is it gives notice. It's hard to somebody to say, well, I didn't know they were using this as a trademark, because it's on the Federal Register. That's one of the major things. And there are some other issues as well that might be a good way to do it, because it provides certain problems in litigation, like damages and attorney's fees, and we're all interested in attorney's fees. So registering the USPTO, it's an actual straightforward process. The biggest problem is selecting and describing the goods, because you have to find out which class and exactly what you're doing, and to describe it in a decent amount. Something Ed might be familiar with patent claims. You have to describe it so it's specific, but still covers a few things that it might not be available. After that, there are some maintenance issues. I can get to that if you'd like. And finally, some other problems. Talk really quickly about Ohio. You have to register with the Secretary of State with your company name in some way if you want to enhance your ability to sue in Ohio. If you have a plan to use a trademark, there's something called an intent to use application, which you can file for, similar to a trademark registration. It's good for 1 year. You can renew it, but it gives you some way to at least keep your place in line, okay? There's an actual cost to that, obviously, and then you have the cost of the actual application once you're using the mark. Since it's a really big question about fair use and everybody goes around using intellectual property saying, oh, well, it's fair use. Trademark fair use is similar to copyright fair use in some ways. By my estimation, that's not an official legal ruling, but it's a lot more narrow and specific. You can only use it just enough. So, for example, if you have a restaurant and you serve Coca-Cola and you want people to know you serve Coca-Cola, yeah, you could probably say we serve Coca-Cola products. You cannot make big, huge Coca-Cola signs and put them all up around your business saying drink Coke here, because that's using the trademark too much. You're not using it just enough to get the thing across. There's also certain free speech issues as well about trademark. And this usually isn't important because it comes around to artistry and parody and things like that. This is still a very tricky topic because you cannot degrade the brand or anything like that. And there have been a few famous cases. Probably the most recent one that made news was the Blender Barbie. An artist put Barbie in a blender and called it art and took pictures of it. And Mattel sued over that and lost because the free speech considerations regarding commenting on the symbolism of Barbie overrode any trademark things. That's what I'll cover right now, and I'll move on to Tom. I'm sorry I went over time.
All right, excellent. Well, thank you, George, for that really richly detailed presentation. We really appreciate it. So without further ado, Tom, take it away, please.
All right, I am Tom Horowitz. I'm a commercial attorney. I work with a lot of small businesses. I have my own firm over here in Westlake. I got interested in working with the VLA because I have a musical background. The original goal out of high school was I was going to be a concert pianist. So I enrolled at CIM towards a bachelor's, realized musicians, no matter how talented they are, no matter how hard they work, a lot of them wind up teaching. And I'm not a teacher like that. So I transferred across the street to Case, picked up a double major, English and music, graduated, went back home to Chicago for a few years, came back to Case for law school, met a cute girl at a party, and we've been together every day ever since. Please don't tell my wife. So I'm here to talk about copyrights, which is one of the pillars of intellectual property. Let me just try and figure out here we go, and share, and from beginning. There we go. All right. So these are, I focus on photograph, copyrights of photographs, because copyrights also apply to musical works, but I'd have to sing and nobody wants that. Trust me. I don't sing and the world is a better place for it. So anyways, how are copyrights created? Very similar to trademarks, but you go to the U.S. Copyright Office instead of the PTO. Copyrights are, exclusively federal law under the Constitution. There's no state copyright protections, but, as George, touched on, there are trademarks protections there are some trademarks protections under state law, and logo protections too. The way you would create a copyright is basically you just would create some work of art and then slap that slap on the copyright symbol, the C in a circle, and some kind of identifying mark. It's a copyright? Yes and no. It's a copyright, but that in and of itself won't allow you to enforce it. You can't go into a court and say, hey, this person infringed my copyright, unless you've actually registered it with the Copyright Office. So it's basically, you would just have a right without a remedy. So if you register it with the Copyright Office, then the courts are open to you. You can have a court consider whether or not somebody's infringing on your copyright. You can get the court to issue injunctions, damages, and the whole kit and caboodle. But you need to definitely register the copyright. The registration, it could take it takes a few months, and there are various fees associated with it. What happens if somebody does infringe on your copyright? Well, it's you only have it if somebody excuse me. Okay. Well, it's if somebody infringes on it, file a lawsuit. You can basically get your attorney's fees and your expenses, including the filing fees, court order, and get a court order to stop it. To stop using your copyrighted material without your permission, stop the future use. If you have actual damages, the court can award actual damages to you, such as lost, not your lost profits, but the profits that the infringer generated. There are also statutory damages. If sometimes it might not be feasible to come up with actual damages, and those vary. Those vary between depending on the infringement. And the copyright holder, yes, you do have to decide, do I want go for actual damages, the infringer's profits, or do I want to go for the statutory damages? And for that, you have to make a calculation. What's going to be what's going to be greater? Just to illustrate a copyright case. This is a case that came out of the Fourth Circuit last year, 2019. In this case, there was a photographer, Brammer, who, he's in the DC area, and he just takes photographs of the neighborhood, of the various areas of DC and the outlying areas, artistic photographs suitable for framing. And he has a website. Well, somebody went on his website. This is somebody was promoting a concert festival, saw this nice picture, the one on the right, the one on the one on the left, and said, "Oh wow, that's going to help me promote this festival that's coming up in DC." It's the Adams Morgan is the name of a neighborhood in DC. So so he cropped it. He cropped it and put it into the pamphlet that in which he was advertising the music festival. Brammer didn't like that. He sued, and he won. The court went into a fairly decent long discussion as to why this was an infringement. The infringer, Violent Hughes, claimed, "Hey, it's fair use." To which the court said, "Well, fair use is that is a valid defense against a copyright infringement. If it's if it is fair use. For fair use, there is a number of factors to consider, such as what was the purpose or the use of the copyrighted material by the infringer. Was it in a new or different way than the original than the copyright holder would use it. Sometimes you can use get fair use for using copyrighted material for technology. A lot of schools use some software programs to look for plagiarism, detect plagiarism. And in order to detect plagiarism, you got to know what's written so they can compare what a student wrote. And sometimes you can use it for documentary purposes. If you are, for example, making a pictorial history of the Grateful Dead, you're probably going to include some concert posters for the Grateful Dead. those posters are protected by copyrights. Also for fair use, they'll look into what is the nature of the copyrighted work, how much creativity went into it. Now, in terms of you know, these photographs, I mean, the way that the way that the lights were trailing. I don't know much about photography, but you know, there's trailing lights. You know, just the way the whole scene is presented. That you know, that could be recreated, and maybe the infringer could have tried and recreate it, just set up a camera at the same angle with the same kind of exposure, so that comes up with the same picture. But instead, this infringer decided just to use the photograph. They, for fair use, they also try to see how much of the copyrighted material is being used. In this case, I mean, yeah, he cut off some of the infringer did cut off some of it, some of the darker areas of the photograph, but not enough to say that, you know, this is just a that this is fair use. And then what would the effect of having this you know, infringer be, you know, used? What's the effect on the copyright holder? What the infringer's use? And you know, if the you know, the copyright holder, the creator, can show that he made a sale, which, you know, he did make, the photographer did make sales, you know, that weighs heavily against the infringer. It's just not, you know, something that's out there for anybody to use. But these are just factors that a court will look at to determine whether or not you know, it falls under fair use of copyrighted material. Now, copyrights do expire, and when they expire, the copyrighted works are then become part of what's called the public domain. Means there's no copyright protection for it. Anybody can use it. Currently, the current law is it becomes public domain 70 years after the creator's death. That's a general rule. Somebody, if you know the singer Eric Carmen from the mid 70s, he got into trouble with a few of his songs. If you know that song "All by Myself," he lifted it from Rachmaninoff's Second Piano Concerto. It's almost the same melody, same harmonies, you know, same lush romantic feel. And he thought it was okay. You know, he thought he was complying with the copyright laws at the time. And I believe he did, but not in this country. In this country, it was a copyright violation. The Rachmaninoff estate got in touch with him and said, "Hey, listen, you know, you got to, you know, what about us? You got to, you need to take care of us here." And as it turns out, he is now, the Rachmaninoff estate is getting 12% of the royalties for that song, and then for another song he put out, "I'll Never Fall in Love Again," which is based on Rachmaninoff's Third Symphony. It's another, you know, more or less a blatant ripoff, if you want to call it that. But they are sharing royalties with the Rachmaninoff estate for that. Well, is there, you know, are there any questions here? I'm sorry, I feel, you know, I know we're a little bit under the gun here.
Yeah, no, Tom, that's great. And by the way, I hadn't previously been aware of the Eric Carmen litigation. So thanks for bringing that to all of our attention. That's a good story.
Yeah, it was a while ago.
Sure. Yeah, absolutely. But yeah, I mean, on the subject of questions, I don't see anything coming through the chat, but just in the couple of minutes that we have remaining, you know, I'm happy to ask just like a couple of sort of real life examples that are representative of the types of questions that we often receive as committee members of the Volunteer Lawyers for the Arts. So Tom, you know, for example, taking your music background, I'll ask you a kind of music question. So let's say there's a rock band who approaches VLA. They've written a number of original songs that consist of both music and lyrics. you know, and this band is really interested in protecting their, you know, their rights in these song compositions. You know, what are some issues that you, you know, would point out to them, you know, particularly where you have multiple members who've contributed to a creative work? What, you know, what are the issues that are presented in a scenario like that?
Well, for that, I mean, you more or less have, you know, what's more like a corporate copyright. You know, it expires. Now, you can't say expires after the 70 years after this person dies. It has to be when no, you know, the when it enters the public domain is different. You know what? You know, it's basically, you know, I would tell them, well, you have to decide how, you know, about the royalties. You know, let's incorporate yourselves. You know, let's incorporate the name of the band, and then we can have the band hold the copyright. It's interesting that you asked me this. I'm in a cover band, the Showgoats. I hate that name, but anyway, we haven't played in a while because of COVID. But you know, yeah, we do a lot of cover songs, and every song we play is a copyright infringement. But you know, if we ever decided to do some original stuff, then we would have to decide whether or not, okay, do we really want to, you know, formalize this and have, you know, get copyright protection at that time. So it's yeah, it would basically, you know, you can basically have a corporate entity own a copyright.
Right. That's a really good demonstration, I think, Tom, of, you know, not only are there intellectual property concerns that are oftentimes raised by artists who apply to us for legal assistance, but oftentimes there are business considerations as well. And sometimes, you know, handling those kind of underlying maybe business organizations issues, you know, are important before even kind of approaching the intellectual property issues as well. So good point there. And George, just kind of in the minute or so that we have left, you know, just staying with our band example, for instance, let's say this particular band, you know, they have a name, they're interested in protecting their name, but they discover, you know, and they perform in Northeast Ohio, but they discover that, you know, out in Seattle, there's another band with the same or very similar name. You know, what can they do from a registration standpoint?
Well, I mean, as long as the Seattle band has not registered anything, we might, you know, there might be, they could probably register it. The problem is they'll eventually have to sort out what common law rights that band in Seattle might have, because their use pre-exists, potentially pre-exists the other band. It's a question of priority, basically, who used it first and for what and for where and all that other stuff. Generally speaking, though, if you find out that some group has been touring since 1965 and you've only started up in 2000, it's probably a better idea to change the name in some way. Generally speaking, basically, you want to avoid confusion, that name change. Also, as well, a lot of band names are usually can be pretty generic. You know, the Sound Machine. You know, that may be a little bit difficult to say that they have a common law. They may have a common law right to that because it's so descriptive. You know, and those factors I discussed would even go for there. But generally speaking, you want to make sure that nobody else is using it first. And if somebody else is using it first, did they use it before you or not? And those are the basic types of questions you want to be looking at. That if they find out somebody else in Seattle is using that name.
Great. Actually, George, there's a follow-up question that has just come in actually for you from a member of the audience. And so they've asked, let's say that the band, they've been together for a while, they haven't yet trademarked their name, but they have registered several copyrights for some of their original compositions. Would having those copyright registrations assist their trademark registration in any way, or are these two things completely unrelated?
No, I mean, registering the copyright might be able to more conclusively establish first use of that trademark and that band name, The fact that we've gone off and we've registered the copyrights under our band names working and entity for business purposes is basically showing that, yes, we have been using this in commerce in some way since we've at least filed the trademark, or excuse me, since we at least filed the copyrights. Part of the problem with trademarks, obviously, is that they're pretty skeptical on claims of first use. There's a lot of self-serving things you can do, to say, like, oh yeah, well, we started in our garage back when I was in junior high, that might be, that's not really first use in commerce, or it's hard to establish that through an independent record. So yeah, I mean, registering the copyrights might be able to give a first use, but it doesn't give you much trade protection. It doesn't give you the advantages of the registration, and it doesn't put people on notice, that you have this mark that you're using in commerce, but it would help with that question of who was using the mark first potentially.
Awesome. Yeah, no, that was a really interesting question. So really, I mean, I think, unfortunately, we're kind of at the top, just past the top of our hour here. So I'm really just going to take this opportunity to wrap things up and once again, thank our three panelists and our wonderful panelists and wonderful volunteers to the VLA, as well as everyone who attended. And just to say that, as I think was clearly evident in this evening's presentation, these are all complicated, multi-layered issues. So if you are an artist, a creative person in Northeast Ohio, if you have questions, if you want to, or if you're a volunteer, if you're a lawyer and you're interested in getting involved with the VLA and serving the local creative community here through pro bono legal services, I strongly, strongly encourage you to get in touch. You can find all of our information on the Cleveland Metropolitan Bar Association's website. You're welcome to reach out to all of us individually, and we'll be happy to try to point you towards resources and answers. But once again, I just want to take this opportunity. Thanks to Ed, to Tom, and to George for all of your wonderful input. We've really only scratched the surface of these topics, but hopefully that was a useful demonstration to any potential volunteers of just the types of things that, the types of issues and questions that so regularly come up with creatives in our local community here in Northeast Ohio. So with that said, thank you once again for tuning in. It's been great to have you, and best wishes to all for a healthy and happy holiday season. Take care, everyone.